Similarly, recent political developments in Rivers State involving both the executive and legislative arms of the state government have sparked significant debate and concern among civil society organizations. These organizations describe the situation as potentially detrimental to democratic principles and the rule of law. At a press conference in Abuja, a coalition of civil rights organizations questioned the contradictory orders issued by the Federal High Court and the Rivers State High Court. The Executive Secretary of the Center for Credible Leadership and Citizens Awareness, Nwabu Gabriel, emphasized that the Rivers State High Court lacks jurisdiction over matters related to the tenure of the State Assembly.
Where the rule of law stipulates the supremacy and predominance of the law and where it has to be followed to the letter. Ladies and gentlemen, we are talking about a purported assembly where three persons parade themselves as lawmakers for the entire state, contradicting clearly the provisions of Section 96, subsection 1, as amended of the Constitution of the Federal Republic of Nigeria, which defines 1/3 as what constitutes a quorum. If for any reason, according to the dictates of the Constitution, if for any reason the Assembly cannot form a quorum, the Assembly shall adjourn. It is never the intendment of those who crafted the 1999 Constitution that only 3 lawmakers shall be enacting laws for the people. The National Judicial Council, the NJC, as a body empowered to regulate the discipline of erring judicial officer, has recently slammed its hammers on 3 erring judges by issuing them with a warning letter. This letter prohibits them from any form of elevation until such warnings are lifted. It becomes imperative, therefore, that we call on the NJC to beam its searchlight on Honorable Justice C.N. Wali of the Rivers State High Court for issuing an ex parte order contradicting clearly the provisions of Section 272, subsection 3 of the 1999 Constitution and violating a subsisting judgment made by Justice J.K. Omotosho, stating that the Assembly led by Right Honorable Martin Sameule is the Assembly that is recognized by law and is certified by court.
They also condemned the relocation of the legislative arm to the government house, calling it an aberration that violates the principle of separation of power.
The Chief Executive of Rivers State has relocated the legislative arm of government, an institution of government, to commence sitting inside the government house. This singular act is not consistent with the principles of separation of power. A complete aberration, desecration, and denigration of our Constitution. We are saying that in all decency, what the governor ought to have done was to write the legislative chamber, that he wants to come to the State Assembly, which is the right channel and the right thing to do, not to bandit thugs who will jump in and break the gate. And again, recall that this State Assembly we are talking about was just built 2 years ago. So what is informing the demolition? We are worried about the happenings in Rivers State. We are worried because we are a coalition of civil society organizations that is embedded in good governance and the rule of law. What is the rule of law? We are saying that it has to be the supremacy and predominance of the law in any given state of society. But what we are seeing in Rivers State, in the mildest possible term, is not synonymous with modern democracy. We are seeing a situation where the governor of Rivers State is spending money outside appropriation. Where is it done? Who does that?
Governor Sim Fubara's plans to probe the previous administration where he served as Accountant General were also questioned. The coalition suggested that these actions might have hidden political motives, thereby undermining the legitimacy of the inquiry.